Well, the Midas Touch Network reports a big deal that this brief was accepted to the D.C. Court of Appeals in the immunity claim appeal of Donald Trump. Now, this brief was filed on or about thereabouts October 30th in the lower court to assist Judge Chutkan in ruling on the immunity motion of Donald Trump. Several other things were submitted to Judge Chutkan which don't appear on the record, and many were submitted that were denied, refused. This brief is on the website Remove Trump, which is on govshout.com. You can go there and read it yourself, but the Midas Touch video you can find here on YouTube. Midas Touch is 3 attorneys, and they're after the advertising buck. They claim that they're unapologetically Democratic, and they don't offer anything. They don't offer solutions, and it's just 3 guys that want to run their mouths forever and whine about Donald Trump. Ben Meiselas, Michael Popak, and Ron Filipkowski, who's not making videos. He's behind the scenes editing their websites. Their website is designed to sell merchandise, post as many videos as possible so that they get as much access to advertising dollars as possible. They've got a pretty big subscription following, so, you know, they may well be making pretty good money. There's also another attorney, Karen Friedman Agnifilo. I don't know how they work it, but if you post something to their site that's any kind of a solution, it either disappears or, well, it disappears. And so, you know, they're not unapologetically Democratic. They're not helping in this nightmare with Trump. Now, here you can find information on the real proper way to have tried to get secretaries of state to remove Trump, and many of the orders and complaints. The October 30th filing, amicus brief of Ludwig and others, is found here at the very end where it says here, and it is the first time Article 2, Section 1, Clause 1 is mentioned in argument. Now, this is something all the officials on Midas Touch missed from October 30th forward. But Judge Ludwig, after this was filed, went on MSNBC 3 days later and laid out the problem with the Colorado suit, Minnesota suit, and how and why the insurrection had nothing to do with it that we think of on January 6th. Of course, Nicole, you know, she wanted to understand it so much, she jumped right over him trying to explain the difference between the Constitution of the United States in rebellion against and the physical insurrection. That clip is next.
The effort to overturn the 2020 presidential election was not and is not politics. This is, as we now know from the indictments of the former president by the Department of Justice and Jack Smith, these were grave crimes against the United States of America. Perhaps almost as grave as would have been treason. The question under the Constitution, and we're talking now about the 14th Amendment, Section 3, as you read, is whether or not the former president engaged in an insurrection or rebellion against the United States Constitution. The question is not whether he engaged in an insurrection or rebellion against the United States of America or the authority of the United States of America. That's the issue that's at stake. That's the issue that will eventually have to be decided by the Supreme Court of the United States. Well, Professor Tribe and I have followed and monitored the various state and federal court proceedings.
If the Congress votes to remove the disqualification and say you've paid your penance or whatever, then you can run. So there is actually here a democratic process the way there isn't for, say, the natural-born citizen.
The former president's lawyers are not arguing their case under Section 3. They are arguing that the former president did not engage in an insurrection or rebellion against the United States of America. That is a difficult case, but it's still a provable case. That's exactly what I want to say today. Okay. Focus on the distinction. Section 3 disqualifies one who has engaged in an insurrection or rebellion against the Constitution of the United States. Now, that case can be made, as I've said publicly, by proving that Donald Trump had a plan and that he attempted to overturn the 2020 presidential election and remain in power in direct contradiction and violation of what's known as the executive vesting clause. The executive vesting clause is very simple. That's just the clause in the Constitution that prescribes the term for the President of the United States as being 4 years. Mm-hmm. And that clause says, by terms, that the President will serve a 4-year term and a 4-year term only unless he is elected or reelected to the office of president. So when Donald Trump tried to overturn the 2020 presidential election that he had lost fair and square to then candidate and now President Joe Biden, he violated the executive vesting clause of the Constitution. That is what I have said is the quintessential insurrection or rebellion against the Constitution of the United States. And so
the refusal to leave office, the refusal to concede, and the refusal to carry out the tradition of a peaceful transfer of power is the damage, is the violation of the Constitution.
It is the rebellion against the Constitution of the United States. And so back to what the former president's lawyers are arguing, that they don't want to argue that. They want to argue instead that the former president didn't engage in an insurrection against the United States. They want to argue that he was not responsible for the riot on the United States Capitol. That's
they're going to play semantics and say, how is he supposed to know? Be there, be wild would make them
exactly.
But you're saying that's not what Section 3 of the 14th Amendment says.
Exactly, and I've not followed closely these two cases, but I've followed them a little bit to the extent that I know that that's what they're arguing. I know that that's not the issue, mm-hmm. And I've been concerned over this past week, frankly, that by the various courts' reactions to that argument, namely, it's not been clear from the court's questions that the two courts that I'm talking about now in Colorado and in Minnesota have focused just yet on the actual issue.
Because you're saying they're taking the bait on questions and evidence about violence, and you're saying that the evidence, frankly, the evidence exists in emails that I think Trump is on the record in the congressional probe as having seen, where Eastman circulates the document and Trump is for it.
That's exactly right, although I wouldn't have worded it the way you did.
Cue the record scratch. Because here, Judge Ludwig is, in the clearest way yet, trying to directly warn that there is a problem with the Colorado Supreme Court ruling. Velshi, who is the interviewer here, is so busy running his non-lawyer mouth that he's not hearing what the judge is really saying. Because that's what happens when you don't have a legal education. You're not listening. Or I should say, you don't know how to listen to what is important. Judge Ludwig has previously, before the interview begins, picked out a specific part of the Colorado Supreme Court ruling which he thinks is going to be a problem at the Supreme Court.
I'm joined now by one of the people who brought this issue to the forefront of the nation's public consciousness and who has helped us understand the nuances of the case, the esteemed former federal judge, J. Michael Luttig. Judge Luttig, again, thank you for being here. You and I have talked a couple times this week, but it's not enough because there's so much to this important case, this important 68-page ruling that I wanted to talk to you again. So again, thank you for being with us. Let's start with the Colorado Supreme Court disagreeing with the lower court in Colorado on one key point, that the president is an officer of the United States. On the other hand, both courts agreed that January 6th was an insurrection, that Donald Trump engaged in it. Colorado Supreme Court addressed that issue in the ruling by writing, although we acknowledge that these definitions vary and some are arguably broader than others, for purposes of deciding this case, we need not adopt a single all-encompassing definition of the word insurrection. Rather, it suffices for us to conclude that any definition of insurrection for purposes of Section 3 would encompass a concerted and public use of force or threat of force by a group of people to hinder or prevent the U.S. government from taking the actions necessary to accomplish a peaceful transfer of power in this country. End quote. Judge, you believe this will be the crux of the case if it reaches the Supreme Court?
Okay, Judge Ludwig is trying to warn people what the problem is going to be with the Colorado Supreme Court's ruling when and if it goes to the United States Supreme Court. He has been consistently saying that the definition that Section 3 of the 14th Amendment requires is one that addresses a rebellion against the Constitution of the United States. It's blowing over everyone's head. He keeps saying it, and he's getting a little antsy because no one's hearing it. He says it, and they blow right past it. Now, some of that is Judge Ludwig's problem because he takes too long to say things. He starts orating, and you have to listen so carefully to the words that matter and the words that don't. And 90% of it doesn't matter. He's like a judge trying to write an opinion on the fly out of his mouth. He's trying to warn that nowhere is Article 2, Section 1, Clause 1 used as the definition of insurrection or rebellion against the Constitution of the United States. And the clip that's going to be after this one from Morning Joe, the day after the ruling, he says it very clearly. It's against the Constitution of the United States, not against the United States or the laws of the United States. And he once again said earlier, it's a world of difference in constitutional law. You know, one needs, like a breach of contract, a specific clause identified in the Constitution to be a rebellion against the Constitution of the United States. And the Colorado Supreme Court has focused on January 6th's insurrection. And then they picked the narrowest possible definition they could find for insurrection, when insurrection, the physical insurrection, the riot, has almost legally nothing to do with President Trump's legal culpability under Section 3 of the 14th Amendment. This is where the United States Supreme Court could pick up the order and do something. It doesn't specifically identify what Trump is doing, although red pare mutual with the D.C. indictment case, and although everybody keeps saying it's not charged there, insurrection is not charged there, they're not getting the point. The point is Jack Smith could not charge it there because he would have run into a free speech argument, as Judge Ludwig said in another interview to the Washington Post. It doesn't need to be charged there because it is the conduct of Donald Trump which must be focused on, not the January 6th riot. And that's the problem. He's trying to tell you without blowing it that this is going to be a problem. And he says it right here in this interview. And I'm going to cut and jump to the relevant pieces and then jump to the Morning Joe quote for December 20th, I believe it is, which you can find on MSNBC's page in totality. And I will see if I can show here the link to this specific clip, which is also on MSNBC's page. Here is the YouTube number for a link to this segment that you can go watch in totality. Now, it's an MSNBC post, and they have cut it from the show. You don't need the YouTube. It could be www.youtube also. YouTube will switch it if it detects a different browser. But this is the number. Now, there's just no good way to say this. The United States Supreme Court doesn't have jurisdiction, and Neil Katyal has politely said it, opposite Judge Ludwig in another interview, which will play after the one after this, the Morning Joe one, where he specifically says that. But everyone's trying to be political and not appear to tell judges they don't have power. And unless Congress steps up and snatches this and casts a vote on it in the Senate to concrete the Colorado Supreme Court ruling, then anything could happen. They could declare it null and void because, as I just said, Article 2, Section 1, Clause 1 is the relevant rebellion that Donald Trump is engaged in the insurrection by. It's not January 6th. It's not a definition of the physical rebellion, because the Colorado Supreme Court has defined insurrection through the physical terms of an insurrection, as Velshi just read. So, let's continue with what Judge Ludwig is talking about.
I do, Ali, and thank you for having me on this morning. The Colorado Supreme Court's decision is historic in its own right. Then turning to the insurrection holding, pivotal to that decision by the Colorado Supreme Court is the definition that you read to your viewers this morning. The Colorado Supreme Court canvassed all of the possible definitions of insurrection or rebellion from the time of the framing and ratification of the 14th Amendment. And there were a number of possible definitions. The Colorado Supreme Court wisely chose the narrowest possible of those definitions and said it need not go broader because that narrowest interpretation of insurrection or rebellion would extend to the former president's conduct before, on, and after January 6th.
I don't know how you remember to answer my two questions. I hardly remember that I asked two questions. Your brain is amazing, Judge. Let me ask you about a point that some have made, that disqualifying a GOP frontrunner is anti-democratic, even if it's legally sound. I want to quote from the New York Times, where they wrote, "The Colorado Supreme Court's ruling that Donald J. Trump is constitutionally ineligible to run for president again pits one fundamental value against another, giving voters in a democracy the right to pick their leaders versus ensuring that no one is above the law. Mr. Trump's status as the Republican frontrunner for the presidential nomination, despite his role in the events that culminated in the attacks on the Capitol on January 6, 2021, has created severe tensions between those two principles. If the court's legal reasoning is correct, obeying the rule of law produces an anti-democratic result," end quote. You have pushed back on this idea on social media. You think that's not a valid interpretation of what's going on here?
I do not. And the passage from the New York Times story that you just read is just fundamentally wrong. It seems to me that no sooner than had the Colorado Supreme Court ruled, than the politicians, but also, surprisingly to me and disappointingly, the national media took up the cause of not enforcing the 14th Amendment against the former president, notwithstanding its clear application to the former president because of his conduct around January 6th. That's misleading. And yesterday I tweeted or whatever one does these days on former Twitter to address this point, because it is of surpassing importance to the resolution of the 14th Amendment question. And I said in that tweet that that it is the Constitution itself, Allie, that tells us that disqualification is not anti-democratic. Indeed, the Constitution tells us that it is the conduct that can give rise to disqualification, namely an insurrection or rebellion. That is anti-democratic. To me, that's about as clear as any document or constitution could make that point. I will say that instinctively, but instinctively only, it is a natural and expected reaction by all Americans, frankly. I would have hoped not by the national media, but by all Americans who are less informed and knowledgeable about our Constitution than the media is supposed to be. But upon thinking about it seriously, I think it's crystal clear, and it will be crystal clear to the American public, that it's the Constitution of the United States that's disqualifying the former president from higher office if he is to be disqualified. To speak to the political warriors, it's not President Joe Biden, it's not the Democrats, it's not the anti-Trumpers, it's the Constitution of the United States. And that's why I've said over the past week that this case tests America's commitment to its own democracy, the Constitution, and the rule of law. Section 3 of the 14th Amendment allows for, and according to the Colorado Supreme Court, requires the disqualification of the president. If he's disqualified, that is the constitutional answer and the law of the land, Allie.
Judge, I want to ask you about an article that was written in The Atlantic by Adam Serwer the other day. It's entitled, "The Colorado Ruling Calls the Originalists Bluff." And it says, there are a lot of practical reasons for opposing Donald Trump's disqualification. One is that it removes the choice of rejecting Trump from the electorate, which might seem undemocratic, even if done with constitutional provisions adopted by the people's chosen representatives. Another is that it could damage the legitimacy of democracy itself by appearing to confirm Trump's allegations that the political system is rigged against him. These are all compelling reasons to avoid or disregard this provision, notwithstanding its plain meaning and intent. A second rejection of Trump at the ballot box seems like the least destabilizing outcome. The problem for a majority of the justices on the Supreme Court is that they're not supposed to care about any of this, to a point that you were just making. They're originalists, remember? You've made the similar argument that based on the plain language of this clause, Donald Trump, by engaging in insurrection, simply doesn't meet this qualification to hold public office again. This is tricky, right? If you're an originalist on the Supreme Court and you say this is what the thing says, then you can't be bothered by the noise outside.
That's true, Allie. I haven't had the opportunity to read Adam's piece, but based on what you said, I would say this, reiterating in part what I've said earlier. This is not politics. This is the Constitution of the United States, and it poses for the Supreme Court of the United States a pure question of constitutional law. The Supreme Court of the United States is never to consider extrajudicial factors or considerations such as partisan politics or even politics writ large. Let alone is it supposed to consider things like have been reported recently in the major media, and not reported, urged by the national media, that rather than interpret the Constitution as it's written, the Supreme Court should instead fashion an opinion of statecraft, which is shorthand to those of us in the law, to fashion a result under the Constitution other than the one compelled by the Constitution. Allie?
Judge Ludwig is going to tell Velshi exactly what's wrong and the world by way of the internet, by way of YouTube, by way of MSNBC. Nobody's hearing it. Almost nobody's hearing it. And certainly I don't think Crew and Donald Sherman and Noah Bookbinder and his entire crew are not hearing it. They have been advised that they need to respond to any filing in the Supreme Court with an objection to jurisdiction and request to transfer the ruling to Congress for a vote because the Supreme Court doesn't have jurisdiction. It is the final sentence of Section 3 of the 14th Amendment. The one everybody leaves out, doesn't read. Why? They don't understand it. They think it's non-consequential. But it is the jurisdictional statement. It doesn't say the Supreme Court does not have jurisdiction. It says it the opposite way. The Congress has the power to relieve the disability. That means the Supreme Court does not. Now, there was no ruling in Colorado until the Colorado Supreme Court reversed the 2 to 3 findings of question of officer, question of oath, and then upheld the rest of the ruling underneath by the district court in Colorado. That is when the determination was made that he was to be barred from office. At that point, all appeals are off. If it had occurred in the district court below, at that point, all appeals would have been off also. And it jumps then, immediately, to congressional jurisdiction to vote on whether they think whoever the trier of fact, in this case the Colorado Supreme Court, got it right. It requires a 2/3 vote in both houses, which means if you don't reach a 2/3 vote in the first house, there's no sense in the second house even voting. Trump will never make that. He will never make a 2/3 vote that he be relieved of the disability of the automatic bar to office. And it's very painful watching all these channels, these YouTubers and these MSNBC shows with these hosts that want to talk fast, lean in, think they understand it, and they are all missing it. Judge Ludwig is just like a tree sloth quietly telling you, you don't get it. He's trying not to destroy the case for Crew in their appeal, but he's also trying to warn them this is a problem. And if Crew was to catch it head on and resist the Supreme Court, and if the country was to resist the Supreme Court, this decision could be poured into concrete by Congress. Only a few people get it. Neil Katyal says it, and he will be in the video a few videos down, specifically saying that. Judge Ludwig gets it, but he can't go against the judiciary of which he is such a close member and give away what he thinks the Supreme Court would do if they rule against it. And a few other people are saying it, but people are chicken. They don't want to take a firm position that the Supreme Court does not have jurisdiction. That they think will anger the court, and they'll take jurisdiction for sure then. It's possible. If they don't want Trump back in the White House as the pros say, dumb shit, idiot that doesn't understand anything, and especially not law, United States Supreme Court will just uphold the Colorado ruling and not say much else. Declare it to be national, and it'll be over. And in the clip after this, the Morning Joe makes the point that I think the Atlantic or the New York Times says this is the opportunity. They're throwing a bone to the Republican Party to save themselves from themselves. I didn't think I'd ever see anything like this. This whole mess started with Ronald Reagan and his moral majority and several Republican presidents who never did win the national popular vote. And at the end of this video, I will put up a small clip and a link to David Feldman, who postulates, imagine what would have happened had Hillary won in 2016. Well, she did. She did win in 2016. She won by 3 million votes and lost by 77,000 votes across only 3 states, Wisconsin, Michigan, and Pennsylvania. The Electoral College stole the thing from her, but David Feldman postulates what had happened if she had won. And you should really listen to that video, because that was where the turning point became so explosive that has really rocked the country to the point we're in right now today.
NBC contributor Mike Barnicle, member of the New York Times editorial board Mara Gay, conservative lawyer George Conway, and staff writer for The Atlantic, David Frum. A lot going on this morning, and we start with that historic decision. The Colorado Supreme Court has ruled Donald Trump is disqualified from holding office again after determining he had engaged in insurrection on January 6, 2021. The 4-3 ruling reverses a lower court decision and effectively keeps the former president off the state's presidential primary ballot next year. The court stayed its decision until January 4th to allow for any further appeals, and the Trump team is already vowing they'll be doing just that. But the 4th is just one day before the deadline for the state to print its presidential primary ballots. Colorado Secretary of State Jenna Griswold discussed the tight timeline in an interview last night on MSNBC.
If they take the case, we will make clear to the court the deadlines and the timelines. The bigger thing is if the court does not take the case. As of January 5th, if the U.S. Supreme Court does not take the case or intervene, then Donald Trump will not be on the presidential primary ballot.
Meanwhile, retired conservative Judge J. Michael Ludig, who served on the United States Court of Appeals for the Fourth Circuit, said, quote, this is very, very important. Section 3 disqualifies one who is engaged in insurrection or rebellion against the Constitution of the United States. not an insurrection or rebellion against the United States or the authority of the United States. David, your latest article for The Atlantic is titled "The Colorado Supreme Court Just Gave Republicans a Chance to Save Themselves."
And in it you write this: the U.S. Supreme Court now has the opportunity to offer Republicans an exit from their Trump predicament in time to let some non-insurrectionist candidates win the Republican nomination and contest the presidency. The Colorado court has invited the U.S. political system away from authoritarian disaster, back to normal politics, back to a race where the Biden-Harris ticket faces more or less normal opponents rather than an ex-president who openly yearns to be a dictator. Until now, Trump supporters have been protecting Biden from his own weaknesses by insisting on nominating an even weaker alternative. If upheld by the Supreme Court, the Colorado court's decision might yet save the GOP from itself. Will the GOP consent to be rescued? And this reminds me of what Liz Cheney was saying on Fox News on Monday night, where she was saying there are other candidates who can stand up for this party and bring it back to its roots and actually wage a good fight for the presidency.
I agree with that assessment, Mike, but it goes more than that. The dissents were logically weak. I mean, even if you don't have a lot of rhetoric in a dissent, you often have just this a logic that just slices and dices the majority opinion to bits. And there was none of that. There was nothing in this opinion. In fact, the opinion doesn't really talk about the real issues in the case. They don't dispute that Donald Trump engaged in an insurrection, and they don't dispute that Section 3 of the 14th Amendment bars people who engage in insurrection from running for president or anything else. And what they talked about mostly was state law, and state law doesn't matter anymore because the Supreme Court of the United States cannot overturn findings of state law made by the state's highest court. And not only that, even the things that the dissents were saying about state law seemed kind of trivial and weak. I mean, they were saying things like, "Oh, this is too complicated for our electoral litigation system," which is ludicrous because these systems do things like, remember the Bush v. Gore and the litigation about Chads and everything like that. That can get very, very complicated, and these election litigation systems are designed to resolve that rather quickly, and people can go to jail in criminal cases on 5-day bench trials. The other thing was they said, "Oh well, our Colorado law only deals with qualifications, not disqualifications." And that's just nonsense because logically every qualification is a disqualification and vice versa. The Constitution says you have to be 35 to serve as President of the United States. And that means there's a disqualification. If you're 34 years and 9 months, forget it. And then the closest that they come to talking about the merits of the case was a legal discussion in one of the dissents about whether or not Section 3 of the 14th Amendment is self-executing. And the argument is that, and this is what the Trump people are saying, is, well, you can't just take Section 3 of the 14th Amendment, which says what it says, I mean, and just apply it. The courts can't just apply that because they need Congress to tell them how to do it. And that's ridiculous, too, because there are other provisions in the 14th Amendment, most notably Section 1, which contains the all-important Equal Protection Clause, which protects us all from race discrimination. Nobody says, and there's no textual basis for saying that provision is not self-executing, because if it were, that means that you don't need a law from Congress to say that you can't discriminate against the basis of race. The same thing here. So the weakness of these dissents, and I always read the dissents first when I read appellate opinions because I look for what's the weakness of the majority opinion, and I particularly look at that when there's an intermediate appellate court or state Supreme Court decision that could go up to the Supreme Court, and I read the dissents to see what the battle lines are. And I got to tell you, if Trump's going to win in the Supreme Court, he's got to come up with some better arguments than the dissents had. And if the Supreme Court is going to overturn this decision, those justices need to come up with better arguments. Well, as a good longtime member of the Federal Society, you have to look at the text of the constitutional provision. And the constitutional provision says nothing about convictions. They could have easily, when they wrote that provision, said someone convicted of insurrection cannot hold public office. It does not say that. And so what that means is the courts are free to determine on their own, based upon, the valid judicial processes, what is an insurrection and whether the facts meet that. And what happened here was there was a 5-day trial where Donald Trump and his lawyers got to participate, and the judge made extensive findings. A judge that actually kind of ruled for him on a bogus ground found that he engaged in insurrection, found this by not just a preponderance of the evidence, which is your lower basic civil court standard, but by clear and convincing evidence, which means that it's way more than, more likely than not. It's very, very, very strong evidence, and you don't see the dissents challenging those findings at all. And in fact, there's no basis to challenge the findings. When you go to the majority opinion and you read the 30 or 40 pages, or I don't know how many there are, on what happened on January 6th and what Donald Trump did before and during January 6th, there's no dispute. I mean, we saw it on television, and we know what happened. He fomented, he engaged in an insurrection. He wanted this to happen. And not only that, I mean, there's another provision in Section 3 of the 14th Amendment that talks about giving aid and comfort to enemies of the Constitution. Well, he did that. He was an enemy of the Constitution. So it's really, if this decision gets overturned, it's not going to be on the basis of the factual findings. And I'll say this about a jury trial. There's no basis for demanding a jury trial here. Any first-year law student will tell you that, because this is not the kind of case, it's not the kind of like a civil case for damages where you do get a Seventh Amendment right to a jury trial. This is election litigation. Election litigation is more equitable, and it's more of something that a court of equity does. And there's never jury trials in election cases because they have to be resolved quickly. And such as Bush v. Gore, that's exactly the same thing. There were no juries there.
The Colorado Supreme Court yesterday decided the most consequential and pressing constitutional issue facing the country. Its decision will force the nation to decide, does it believe in American democracy, its Constitution, and the rule of law? The Supreme Court of Colorado issued what I have characterized as a masterful judicial opinion. It is unassailable and irrefutable in every single respect. As your viewers already know, that court held that first and importantly that Section 3 of the 14th Amendment does apply to presidents of the United States. I believe that based on the objective law, which in this instance is Section 3 of the 14th Amendment, there is no other decision that the Supreme Court could make.
Now, what he's saying is, well, let the people decide, which is funny because that's, of course, not what he did in 2020 when he tried to launch the coup. But I think the more important answer to that is that the writers of the 14th Amendment already wrote an answer to that exact concern, because what they said is that Congress can lift any disability of someone being labeled an insurrectionist and allow that person to run. And if Donald Trump can convince the Congress that he's not an insurrectionist, which after all is not all that hard for you and me and normal people,
finally,
he can be on the ballot. But up and until that point, I think the Colorado Supreme Court decision should stand.
Alicia, first let me add to Neil's discussion this point. There's already in the relatively few hours since the decision was issued, a hue and cry by the partisan political people in our nation that the decision is anti-democratic. it is not anti-democratic. The Constitution itself tells us that the disqualification or the possible disqualification of the former president is not what's anti-democratic. Rather, the Constitution tells us it is the conduct that can give rise to disqualification under the 14th Amendment that is anti-democratic. So, in other words, the framers of the 14th Amendment and Section 3 in particular, on behalf of the American people, wrote into the American people's Constitution that disqualification should follow upon an insurrection or rebellion by one who has previously taken the oath to support the Constitution.
Well, finally, final sentence of Section 3 says Congress has jurisdiction. In essence, not the Supreme Court. Katyal has that right. With Stephanie Rule's show, she has Judge J. Michael Ludig on next. None of these hosts have law degrees except Ari Melber and Katie Fang. She asked the typical stupid questions. Okay. For those who are trying to understand this Section 3 issue, it got started wrong. A crew filed a lawsuit. They did it wrong. They brought it as a lawsuit. The Secretary of State in Colorado wanted it to go to court. She wanted a court to tell her because she was afraid to make the ruling herself. She claimed, I can't make that ruling. Well, this is how Section 3 of the 14th Amendment works. If you have an insurrection or rebellion against the Constitution of the United States, not a physical insurrection with people running up to the Capitol and breaking in, but against the Constitution of the United States, that means against a term that's in the Constitution, which in this case was Article 2, Section 1, Clause 1, that specifies that the president has to leave at the end of 4 years. Well, Donald Trump had this fake elector scheme that he had planned a long time ago, and he was trying to stop the counting of the votes so that the certification wouldn't happen and he could use the fake electors. That was the rebellion against the Constitution of the United States. But everybody keeps getting it confused with the physical insurrection we all saw on TV in the media. That ain't the deal. The deal is Article 2, Section 1, Clause 1. And had Crew brought this suit correctly in the first place and argued it correctly, everybody wouldn't be talking about judges making rulings and how, it's all a political witch hunt. That wouldn't apply, because all you do is you apply Article 2, Section 1, Clause 1. Did Trump violate that? Where's your proof? Oh, the fake elector scheme is our proof. They could have simply pointed to the D.C. indictment, and that was the end of it. That's the rebellion against the Constitution of the United States. That way, judges' opinions stay out of it. But no, Crew did it wrong. They started talking about January 6th, and they wanted to go through all this stuff about how, Trump incited the insurrection. It wasn't an insurrection. It was a riot. The insurrection is something that probably would have to go on a lot longer by a larger group of people, just as Trump's lawyers argued. Crew did not argue Article 2, Section 1, Clause 1. They could have just said it over and over again. Article 2, Section 1, Clause 1. He violated it. He tried to stay in office. That's the rebellion against the Constitution of the United States. It's not about a riot against the United States or in the United States or to stop the counting. It was his scheme that would get him barred from holding office again. So now we have a ruling from the Colorado Supreme Court that finally straightens out the lower district court's ruling, which she did the best she could because Crew gave her a mess. She had to, weave in the incitement of the insurrection through January 6th, which has nothing to do with the statute. It has nothing to do with Section 3 of the 14th Amendment in terms of proving it. You have to prove something is violated in the Constitution. It's a quiet coup, a violation of a scheme to violate Article 2, Section 1, Clause 1. Now we have to listen to all these knuckleheads talk about, I don't want judges to determine this, and the voters should determine this. Well, let me tell you something. Voters don't determine it. You don't have a right to determine the president. You really don't have a right to determine who's going to be the primary candidate. You can vote. They usually use it. That doesn't mean anything. The political party can put anybody they want up there. You don't have those rights. And with the Electoral College, you don't have the right to really determine who is the president. The states have that right. And the Supreme Court said that in Bush v. Gore. Or is it Gore v. Bush? Whatever it was, the case in the year 2000, you can look it up on the internet. In the second paragraph, they say individual citizens do not have the right to select the president. Well, everybody thinks they have this and they think they have that. And you know what? This is why legislators and the executive branch, that means senators and representatives, and the president and vice president should all be required to have a law degree and a license to practice, because it teaches you things that you thought you knew and you don't. You got it wrong. And there's a bar exam that's pretty stiff that a lot of people can't manage to pass that tests all of this. And so by the time you get to government, at least you know how government works. Trump doesn't have that. Trump is about as dumb as dumb comes. He is the useful idiot to the Republican Party. He's the figurehead that's dumb enough to sit up there and want to do all these things and think he's doing it. He's not. This thing started back with President Reagan. And they've been trying to take over the country ever since. They've been trying to jam these Christian values down the country's throat ever since. They've been trying to stop abortion and transgender and transsexual and the LGBTQ thing. They've been trying to stop all of that and trying to tell everybody else how to live. People don't want to hear it. It's not a genius thing. People don't want to hear it, but they can't figure that out. The Democrats, on the other hand, are live and let live. They don't really care what anybody else does, except they're dumb enough to get their nose in something when they feel like, oh, this has happened. But guess what? They wake up too late. Now, Democrats are the best thing that happened to the country, but they're also the worst thing, because the Republicans are marching with a plan. And I mean, it's a serious plan. The Project 2025 plan is going to destroy this country if Trump gets back in there. Everybody keeps saying it. The people who've actually read the documents, the people with law degrees, the people who have a legal education who've read this stuff, get it. The media doesn't. The media asks these ding-dong, dumb-ass questions like Stephanie is about to ask. Do you think that, Justice Thomas should recuse himself? Has nothing to do with it. It has to do with enforcing the Constitution. That's it.
Back now to that breaking news out of Colorado. The state Supreme Court has ruled to remove Donald Trump from the state's 2024 ballot for violating the Constitution. With me to discuss, the lawyer who knows all about this, Michael Luddig, celebrated conservative legal scholar who served more than a decade as a judge on the U.S. Court of Appeals in the 4th District. Former Vice President, if you recall, Mike Pence turned to him for advice when Donald Trump asked him to overturn the election results. He went on to testify as a key witness in the January 6th hearings. Judge, I appreciate you joining us tonight. A lot of people are shocked by this news, and they want to understand it. You have called this opinion unassailable. Can you explain why?
Yes, and thank you for having me on with you tonight, Stephanie. I'm not shocked at all, and nor, I think, are the lawyers and others who have followed this case and the others in the other states in recent weeks and months. But this is not a political decision, Stephanie. This is an opinion of constitutional law. It has nothing to do with politics, and I've heard some commentators tonight jump to the conclusion that this is a political decision by a liberal state Supreme Court. It couldn't be anything further from the truth than that. The opinion by the Colorado Supreme Court was a masterful judicial opinion of constitutional law on the applicability of the Section 3 of the 14th Amendment. It will stand the test of time, as they say, and I think that the Supreme Court of the United States ought to affirm this decision, and based on the objective law, in this instance, the 14th Amendment to the United States Constitution, I believe the U.S. Supreme Court will affirm this decision.
Or do you worry that, again, politics will get involved?
Stephanie, I don't even recognize politics within the judicial system, and I'm not going to do that tonight. I believe that the sitting justices on the Supreme Court today, all 9 of them, will apply the Constitution as it is written. I believe that, as written, the disqualification clause, as applied to the former president, disqualifies him from holding the presidency again. And based upon that view of the objective constitutional law, I believe the United States Supreme Court will affirm.
But we begin tonight with the consequences of insurrection. Because lately, it doesn't seem like there have been many for politicians who participated in them. But there absolutely have been some. Let's start with Coy Griffin, a person you probably don't know. Griffin was the co-founder of Cowboys for Trump and was elected as a commissioner of Otero County, New Mexico. Prior to his election, Griffin was an election-denying, false lies-spreading MAGA Republican. He was so committed to the lie that he was convicted in federal court last year of a misdemeanor for entering the U.S. Capitol grounds on January 6, 2021, without going inside. Griffin was sentenced to 14 days in jail and given credit for time served. Citizens for Responsibility and Ethics in Washington, aka CREW, sued to remove him from office on behalf of New Mexico residents on the grounds that his participation in the January 6th insurrection made him ineligible to hold office under Section 3 of the post-Civil War 14th Amendment to the Constitution. A judge agreed, booting him from his position as commissioner and barring him from holding any public office. Couy Griffin is the only successful case to be brought under Section 3 since 1869. The other modern cases that have been filed but failed were against Marjorie Taylor Greene and ousted North Carolina Republican Congressman Madison Cawthorn. All of that is to say that there has been precedent for these kinds of cases, just not for a president of the United States. And we'll find out very soon if the U.S. Supreme Court agrees with the Colorado Supreme Court that Donald Trump is ineligible for office, just like Couy Griffin, because he, too, engaged in insurrection by inciting the riot on January 6th that Griffin and more than 1,000 others got swept up in, and that he did so as a sworn officer of the United States. The Colorado court's decision was clear and unambiguous that Trump incited an insurrection, a point President Biden made yesterday.
Is Trump an insurrectionist, sir?
Well, I think certainly it's self-evident. You saw it all. Now, whether the 14th Amendment applies, we'll let the court make that decision. But he certainly supported an insurrection. And no question about it. None. Zero. And he seems to be doubling down on about everything.
Here's Representative John Bingham's account of what happened when they brought that up. Quote, "Let me call the senator's attention to the words, or hold any office, civil or military, under the United States. Practically speaking, what the authors of Section 3 were saying is that the language was clear and Congress didn't intend for this section to spare the president and the vice president." Joining me now is Congressman Jamie Raskin of Maryland, who was a member of the House January 6th Select Committee. I'm going to skip for a moment, Congressman Raskin, because I have limited time with you and I want to use it all up. The part about Donald Trump trying to once again delay the Supreme Court hearing a very important case because he wants to slow it down by letting the a sort of interregnum court get it first. But I want to go right to the question of whether or not the framers intended the president to be covered by Section 3. I want to show you a picture. This is Donald Trump taking the oath of office, and you, sir, also taking the oath of office. Here is what the president read. I think that picture is going to come up in a second. When he took his oath of office, Donald Trump recited the following: "I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States." Here's what you and other members of Congress said: "I do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I will take this obligation freely without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office of which I am about to enter, so help me God." Benny Thompson, who led the January 6th committee, pointed out that language was adjusted after the Civil War to account for the fact that there had been insurrectionists in their midst. In your mind, in your view, as a constitutional scholar and a congressman, did you and Donald Trump both become officers of the United States?
Well, of course. And the Colorado Supreme Court was very clear that both of these oaths of office are oaths to support the Constitution of the United States. And that's the only commonsensical interpretation. And, I believe that the Colorado court did a terrific job of refuting this bizarre claim that Section 3 of the 14th Amendment applies to every officer in America except for the most important officer in America, the President of the United States. And they demonstrate that the word office or officer is applied to the president or the presidency 25 different times in the Constitution. So I don't think that that poses any serious obstacle to the finding that Donald Trump's conduct was covered by Section 3 of the 14th Amendment, and that that the provision itself applies to him as the President of the United States.
Is it your assumption? We can't get into the heads, although Samuel Alito thinks he can. You can't get into the heads of the people who wrote parts of the Constitution. But would it be a pragmatic and sort of obvious sort of take to say that they didn't specifically name the president because the president, had been assassinated by the insurrectionists, and I guess they didn't have the sort of creativity to imagine that a president would be the one to be the insurrectionist?
Well, it obviously didn't leap to mind for them with Abraham Lincoln as the central figure in rejecting and resisting the insurrection and the secession against the Union. They had in mind the paradigm case of the president defending the Union against all of the secessionists and insurrectionists. In any event, as the Colorado court points out, the language is comprehensive and exhaustive, and the president has always been treated both as an officer of the Constitution and an officer under the United States. I don't think that this matter needs to detain us much longer. I mean, I think that those people who want to defend Trump against the very clear textual meaning of the Constitution and against the very clear original purposes of it are going to have to gravitate around some other idea. More likely, they will say that Congress needs to act, that this is a so-called non-justiciable political question that belongs in the legislative branch. But I just don't think that dog is going to hunt about how the president is not covered by Section 3 of the 14th Amendment. If you go back and look at the legislative history, it's very interesting because the radical Republicans, who were the ones who added this to the Constitution, started off with saying anybody who participated in the Confederacy in insurrection should be disenfranchised forever. And then when it got over to the Senate, they narrowed it down. They said that's far too broad. It shouldn't be anybody who participated in the insurrection. It's just people who swore an oath before and violated the oath. And it shouldn't be disenfranchisement. It shouldn't be about voting. It should be about holding office again. But you can see how Donald Trump's case is right in the bullseye prohibition of Section 3 of the 14th Amendment. He is in the worst case scenario of someone who swore an oath to the Constitution, was supposed to uphold it, betrayed the oath, and proved himself essentially untrustworthy and therefore unfitting for office. And that's why this is called the disqualification clause. And this is a very straightforward interpretation of it. I think that when this case goes up to the Supreme Court, it is going to just be a master exam on whether or not the textualists and the originalists really believe in their own rhetoric, because the text is perfectly clear and the original purposes of Section 3 of the 14th Amendment are overwhelmingly obvious here.
Okay, here's probably the best website to find a large collection of information in blog type form about the Section 3 issue. As previously said, the proper procedure would have been to request a Secretary of State to remove Trump from the ballot based on a specific identification of how the Constitution of the United States had been rebelled against by him in the past. And of course, you need to show some kind of proof. In Trump's case, there is the indictment in D.C. and the indictment in Georgia, both of which are somewhat based on the January 6th Select Committee's decision. It's not a ruling, it's a report, actually. And then the Secretary of State should have made a determination, a ruling. Well, we had two chicken shits scared out their pants in Colorado and in Michigan. Benson and Griswold. Now, Benson had good reason to be scared. They came to her house, and they were beating on the door, and they were camping out on her lawn, and she testified somewhere that she was scared shitless. And then Griswold, sitting up there, pretty much the same way. Now, Griswold's on the western side of the country, which is kind of close to those militia people up there in Idaho, Montana, you know, to Wyoming. They are not really Democratic sorts. Colorado is a Democratic state. It's in the National Popular Vote Compact because the major cities are inhabited by Democrats. But other than that, the state is populated by a lot of wild people, cowboy-type styles. Benson is in Michigan, where there's just bat-crap crazy Republican militias up in the woods of Michigan, Upper and Lower Peninsula. So, you can't really blame them, but, you know, that's the job. Now, the matter should not be going to the Supreme Court of the United States. Jamie Raskin just said, you know, this is what they're going to probably try to say. And he recognizes that's the right thing to say because Congress is the one who has the jurisdiction. But without targeting the Supreme Court or making any push or pull, he took a very proper political stance to kind of be neutral in that interview. Neocatio said the same thing. If the Congress doesn't reverse it, then the decision stands. Judge Ludwig has been pretty clear that the Supreme Court should affirm the decision. Well, he's also been pretty clear, well, not really clear to most people, but he's been clear to me that he sees a problem with the Supreme Court of Colorado ruling. That problem is that the judge below mixed the criminal with the civil definitions and prosecution styles of insurrection in our law. It's only found in two places, 18 U.S.C. 2383 and Section 3, the 14th Amendment. 18 U.S.C. 2383 also has an automatic shall be barred from office. It is a criminal statute, and while it is a criminal statute, there is nothing that says how you prosecute it. Jack Smith is in essence prosecuting it right now because he is showing that through the counts that he's alleged, it amounts to a rebellion against the United States. Now, it's against the United States under criminal law, not the Constitution of the United States. And it's confusing, but they're separate and distinct. The Constitution of the United States is a civil prosecution, meaning you got to find something like, think of the Constitution as a contract. You got to find a term in the contract that's been violated and then say, this is how it's been violated, and therefore they are now disqualified from holding office. In the criminal statute, if you do something, you know, free speech is not absolute. If you do something in free speech and say, you know, go shoot that man, and the other person does it, well, you're liable. You know, you're criminally liable. You incited him to go murder. Well, that's where Trump is. He incited that whole mob to go to the Capitol. But under Section 3 of the 14th Amendment, nobody has pointed out what term of the Constitution was violated. Under an incitement, he clearly incited that insurrection, that riot that everybody calls an insurrection. So, Judge Wallace, as Judge Ludwig says, masterfully wove the two together. And you can't really cut them asunder, because she's ruled that the incitement wasn't engaging in the insurrection by incitement, and that is within the scope of Section 3 of the 14th Amendment, because it's conduct. And that's where Judge Ludwig agrees. That's where Katyal agrees. That's where Jamie Raskin agrees. Now, on this site here, the order, both the orders are here. This is the 208-page ruling from the Colorado Supreme Court. And you can go there and read it if you like. And Judge Ludwig also, in the Trump DC case, along with 6 or 7 other people, filed an amicus brief to Judge Chutkan to assist in her immunity ruling. And it basically, for the first time in the case, cites to Article 2, Section 1, Clause 1, which nobody seemed to be thinking about. And there is a video here that covers how the rulings were mixed. And you can find it on YouTube. You can find it through the site also on YouTube. But Judge Ludwig and his friends, which what they call the I believe it's Society, I can't remember it, but they filed a brief that Judge Chutkan used, which is also here on the site. He also explains here why 2383 could not be used by Jack Smith to file in the original indictment. Now, there's an issue that everyone keeps thinking that you have to be convicted, and it's not true. Now, I was fairly sure that that brief was also here on this site, and I can't find it immediately, but the case has gone on quite a while. And so there's just a lot of stuff. Now, for those of you who don't know, Trump won the election in 2020 by cheating. There's a documentary called Unfair Game, How Trump Won. You can find it here. And in the last few minutes, it's like an hour-long documentary, it shows how he manipulated through social media voters to vote for him. Now, you know, most people might not say that's a big deal, but Trump has recognized that his way to win is to get the weak-minded people and manipulate them. He's recognized that there is a social media way to do that today, and he's using it. He knows that if he can just get on the ballot, and because of the Electoral College, he could probably pull off a win again. The truth is, in 2020, Biden was ahead by 7.4 million votes. He was ahead by 7.4 million votes. He literally won by only 24,000. What? Can't be. What was that? 24,000? That's right. He won by only 24,000 votes across the same three problem states: Wisconsin, Michigan, and Pennsylvania. Now, Trump took those in 2016 by 77,000 votes. And that's why Trump was so indignant that the election was stolen, because he couldn't understand how those flipped on him. Of course, there was also then Georgia that flipped, but by a very narrow margin. And so he has convinced much of the country the election was stolen. Okay, well, here's the deal. You still can't start an insurrection or rebellion, and you can't violate a term of the Constitution, because the Constitution is a contract. It's a contract with the government. It's a contract that is the government. And Judge Ludwig has said throughout the various clips seen in this video that it is the Constitution which fires you. You know, there is no political nothing. There is no judge. Many of these judges would not have a choice. The issue with Couey Griffin is that judge did not have a choice. Griffin violated Section 3 of the 14th Amendment, and the Constitution said he's barred from office. And that's it. So, you know, he threw him out of office. Now, yeah, a lot of people want to hear this. Oh, there's a whole bunch of people in the Congress, the whole Republican caucus, as a matter of fact, who has, guess what? You got it. Given aid and comfort to an insurrectionist, Donald Trump, aid and comfort to enemies in Russia, and have violated their oaths of office to the Constitution of the United States. Now, here's the difference with an ordinary citizen and a member of government. A member of government, the entire Constitution applies to them, including the preamble. Nobody says the preamble has any effect. They say, oh, that's just a nation of intent, a measure of intent. Well, if you take an oath to swear true faith and allegiance to the Constitution, you're sharing true faith and allegiance to the entire Constitution. And when you read the preamble, that's basically a conduct paragraph. It says basically you'll work towards justice. It basically says you won't lie. It basically says that you make an effort to create a more perfect union. It basically says that everything the Republicans are doing is a violation of their oath of office. So 2024 will be the year that will be tested. And if you want to see what Michael Ludig says, that brief is here. It's right after it says, this is Jack Smith's office reply to Trump's motion, October 19th. And then above, Judge Chuckson ruled in the 48-page complete. And there's a little link here, says here. That's Judge Ludig's amicus brief. He and a bunch of people have signed on to it. 1, 2, 3 people actually drafted and submitted it. And go to the end. Somewhere it says who the people are who have sponsored and signed on to the brief. And of course you can't find it when you want it. Here they are. List of amicus curiae, amici curiae. Donald Ayer, John Bellinger, Barbara Comstock, Mickey Edwards, Charles Freed, Stuart Gerson, John Garado, Peter Keller, Edward J. Larson, J. Michael Ludig, Carter Phillips, Alan Rand, Jonathan Rowe, Paul Washington, Nicholas Rustow, and there's more than just 7. It goes on. Wow. Anyway, I encourage you to read it. You find all of these at govshout.com/remove Trump. And it's a collection of links to YouTube articles as well as the proper procedure to request the Secretary of State to remove Trump from the ballot. Now, anyone could take that order from the Colorado Constitution, Colorado Supreme Court Constitutional Section 3 case, and submit it as judicial notice through another court, another filing, even through a federal court, and request a mandamus hearing against the Secretary of State after you've requested that they remove him from the ballot. Now, it's too late for a primary. That doesn't matter anyway. It's the general election that matters. And the funny thing is, the Supreme Court does not have jurisdiction to reverse the ruling. It doesn't mean they won't try. They have jurisdiction to basically say, it's affirmed. We'll send it to Congress to see if they want to reverse it, but we don't have jurisdiction. That's what they should say. Now, if they don't want Trump back in office, if they've recognized that he's a pro se jackass idiot, and he would just load their docket up with just BS cases to the roof, they'll say, bye-bye, Trump. This is the end of your run. It'll be like, it's been real, it's been nice, it ain't been real nice. And that would be the end of Trump. And in theory, and in a perfect world, that's where it should end. This site also has 2 other pages, which offer a solution to America. Things that are wrong with America. And one is saving American democracy. That's here. And it sets out basically a plan and some information about Bush v. Gore, why people really don't vote for the president. And then another one is called The Republicans Are American Russians. which basically sets out some of the more ridiculous links that have been found, how Republicans behave as Russians, and frankly, the problem with Republicans is that they're religious zealots, and they're racial religious zealots. And what's wrong with that? When you stick your head in the Bible and you keep your head in the Bible and you don't want to find anything else out about technology, when you satisfy that everything is caused by God and God willed this and God willed that, God made everything go, then you don't look for the truth and you become unknowledgeable about anything real. And Neil deGrasse Tyson there's a compilation of very long video of him describing what religion is, because everybody kept asking him, are you religious? Don't you believe in God? Do you believe in God? And everybody wants to be so busy calling him an atheist. He never really said any such thing. He said, you do you, I'm not doing that. And it's not that he doesn't believe, it's just that he doesn't see any reason to believe, because there is no proof that that's what it is. And people just have such a hard time with that. And that's where we are in America today. All these religious zealots, they want you to become them. They want you to follow what they say you should do. And the truth is, they're just God delusional. There's a link in this page here to a documentary called God Delusional. It describes it. There's also a link to America at a Crossroads, which touches on the God Delusional. And there's a big issue with evangelicals and the white Christian national movement, which they sort of teamed up together along with the militias in the Northwest, and then Trump with his authoritarianism, and that's what the Republican Party is today, a collection of all those people. Now, they're not enough to win a general election by the national popular vote, but they're enough that if they manipulate the Electoral College properly, they can win again. Almost every Republican president since Reagan has failed the national popular vote. Trump failed it in 2016. He lost by 3 million votes, but won by 77,000 across 3 states. Biden took 7.4 million votes to be ahead and still only won by 24,000 across the same 3 states. And if you follow history back, Bush v. Gore was just absolute lunacy. 30 electoral votes would have decided the presidency by 500 votes. The separation between Bush and Gore was about 500 votes. 500 votes that decides 30 electoral votes that took the presidency, gave it to Bush by a Republican Supreme Court. You know, I could go on for a long time. There is a YouTuber called Leija Miller. You can find her by Leija Miller, Leeja Miller. She's a Minnesota attorney, kind of salty-mouthed, fairly young. She has a collection of videos all about the history of America and the ugliness that has gone on and been swept under the rug. I encourage you to look it up. Look her up. The issue is pretty simple. It's not democracy that's on the ballot. We don't have a democratic system. We have a democratic republic. She also has a video on that. you don't vote for anything. You vote for the poll that votes for anything. You know, your vote would determine who takes the electoral votes of that state, if and only if the state lets you do it. That's how Trump wanted to send it back to the legislatures to change the votes. I'm not going to keep going, but here's the thing. Colorado has decided, they've basically decided for the entire nation, but still, Michigan hangs on. We'll wait for the Supreme Court, and she doesn't understand. Benson and Griswold both are attorneys. Neither one of them get it. They don't understand. This is not something that the Supreme Court handles because the states handle elections. If the state in Colorado, only Colorado, decides not to have Trump on the ballot, that is what it is. Then he loses those electoral votes from that state. Everybody doesn't have to follow the same thing. If he loses enough states that he can't then be on the ballot enough to win the presidency, then that's what it is. You know, I'm at a stumbling point because the mindset of people today would have never been able to create the Constitution of 250 years ago. There isn't enough wisdom today to create a document as encompassing as that and keep it together for 250 years. No one else on the planet has a constitution that is that old and working. Today, people are stupid. They don't know how to think. The thing they think is their mouth engages before their brain engages, and when you try to engage their brain, they can't go there. So they just stick with what somebody else told them. I encourage you to go to this site and the other sites and consider what's really happening in America. Because until you do that, you're blowing smoke. Just like every one of those MSNBC contributors, every one of those YouTubers, and the YouTubers, don't fool yourself. People like the Midas Touch Network and all of them, they're out there to get advertising money. We don't give a damn about the advertising money. We don't have a comment section that's active, and we don't care about the advertising money. It'd be nice. It'd be nice for people to like and subscribe and share the videos. But these other ones, Midas Touch, they're talking about how they're near 2 million subscribers, blah, blah, blah. You know what? They don't present a single solution. And if someone posts a solution to their comment section, it's deleted. They delete it, they remove it. They want these one-line, solutions that nobody has a solution. Great job. Love this video, blah, blah, and nobody's offering anything. So they're not unapologetically democratic because they're not offering a solution. They're not putting forward a potential solution. None of them are. MSNBC, often they cut out the very meat. There's another little Chinese person on YouTube. She puts up MSNBC stuff sometimes, and she puts it up before MSNBC does. Then MSNBC comes along and takes her video and reposts it themselves. It's not funny, but it's funny. And then gets YouTube to block hers. But the bottom line is, these take time. As Legion Miller will tell you, 20 to 25 hours to make one video, of a certain caliber, and she does a lot of research. She has dates, times, going way back. So, like and subscribe if you can. share the video with others, and hope and pray that the Supreme Court of the United States doesn't abuse its power. At worst, at best, they send it to Congress so that Congress can make it absolutely final nationwide. At worst, they reverse it based on the fact that 18 U.S.C. 2383 and Section 3 have been mixed, and no identification has been made for Article 2, Section 1, Clause 1. But I don't think they're going to do that because Trump isn't worth it. But they're letting this all go on too long. The country is like bleeding out. These people need to be told Trump's not viable. Forget it. You know, you've been misled. They're never going to believe it. It's like another Waco. These people are never going to forget. They're not going to, understand. You can't convince them. These people are so far down the rabbit hole. They think the election was stolen when the opposite is true. No, actually, it is true. Trump stole the election in 2016. Now, the last thing I'm going to put up after this is the link to David Feldman with his What If video. Now, David Feldman's an acquired taste. And I'll let you be the judge of that. This is the most sobering video anybody who cares about democracy will see in a while. David Feldman is sort of a dry kind of guy, but this is very poignant. Trump won by 77,000 votes. Cheating across 3 states using Facebook, when Hillary beat him by 3 million votes in the national popular vote. Of course, the way we end all of this is to finish the National Popular Vote Compact. We need constitutional amendment ballot initiatives in Arizona, Missouri, Michigan, Ohio, Nevada, Florida, Oklahoma. And if those passed, the national popular vote will come into effect. Then we need to solidify it permanently with constitutional initiatives in all of those current member states so that the legislatures can't back out that have voter amendment initiatives. There's a danger there is that the voters could, just as easily voted down what the legislature's already done. But at any rate, here is where you can find David Feldman's podcast video. And again, if you replace the M with www, it works. Otherwise, YouTube will change it automatically depending on what your browser is. This is the number of the video. If you notice that the URL always has a question mark, video equals, V equals, and then the number is from here, H45J VRKSYQY, caps matter, and give it a watch. And then, go get a stiff drink, because the truth is, this has gone on since Reagan. The Republicans have been cheating their way into office and slowly screwing up the country. Reagan started all of this with tax cuts to the rich, the moral majority, bringing in the Christian side of the evangelical movement, and it has gotten worse from there. It turned into an abortion battle. Look what happened. So, in my lifetime, I've seen Sputnik, and now this.